Okay, good morning.
Morning, Your Honor.
Good morning.
Okay. Let me introduce you to the other members of the panel, Judge Wallace and Judge Sasso. These oral arguments are being live streamed so that the public can view them. You should also have a clock on your screen so you can see how you're doing time-wise. And if the appellant wants to let me know how much time they wish to reserve for rebuttal, I'll try to assist in that regard.
5 minutes, please, Your Honor.
Okay. All right. Appellant's counsel may proceed.
Thank you, Your Honor. Good morning. May it please the court. My name is Tomasita Carmona on behalf of the appellant. Your Honors, all squares are rectangles, but not all rectangles are squares. This case is about trying to fit a rectangle-shaped peg into a square-shaped hole. Unlike the appellee would have you believe, this foreclosure case is not like the others. There are 3 independent reasons why this court must reverse the ruling of the lower court. 1, the trial court committed reversible error in its application of res judicata. 2, the trial court committed reversible error because it did not apply the doctrine of collateral estoppel to preclude relitigation of the validity of the promissory note. And 3, the court erred in reforming the note when the issue of reformation had been brought up in the prior case and the evidence did not support reformation. I may first begin with the facts of the case.
Familiar with the facts of the case, you can move to your first argument.
I'm sorry, Your Honor, I could not hear you.
Can you hear me now?
It's not really.
I think Judge Sasso was saying we know the facts of the case, so if you'll just move directly to your argument.
Yes, Your Honor, thank you. I thought so. I just didn't want to presume. The standard of review to be applied by this court is de novo. First, the trial court committed reversible error in its failure to apply res judicata to the present case, as it relied primarily on the Supreme Court case of Singleton versus Graymar, 882 Southern 2nd, 1004 and 2004, and its progeny, which are distinguishable from the case at bar. Unlike any of these cases, in this case, the judge in the 2015 foreclosure action, which was a full non-jury trial on the merits, expressly ruled that the underlying obligation, the promissory note, was invalid. Thus, it expressly held that no contractual obligation existed between the parties.
Ms. Carmona, did the trial court actually formally cancel or permanently void the note?
Your Honor, in the 2015 case, Judge White expressly stated in his final judgment that the note and promissory note was invalid.
But canceled or permanently voided the note, that was not done by the trial judge, correct?
Outside of the final judgment, no, it was a pro se case, Your Honor, between the bank and the homeowner.
So the evidence that we have in the court file and the record on appeal does not show that the note was canceled or permanently voided. Is that correct?
That is correct, Your Honor.
Okay. And did you seek the relief of actually invalidating, or did your client seek relief to invalidate the note in the 2015 action?
No, Your Honor, I don't believe they did.
Okay.
Since the existence of a valid and enforceable promissory note is the first element of any foreclosure action, once a court in 2015 ruled that the note was invalid, all subsequent foreclosure actions were barred. Thus, it was reversible error for the trial court to apply Singleton to this case, because in all the other cases in that line of precedent, the underlying obligation was valid, and therefore subsequent defaults were possible. Here, however, the underlying obligation was held to be invalid, and therefore no subsequent defaults were possible as no continuing obligation existed.
Ms. Carmona, let me go ahead. Judge Sasso.
As to collateral estoppel, then, and I think there is some discussion about the distinction between res judicata and collateral estoppel. As to that issue, is it your position that collateral estoppel was raised below and was preserved for this appeal?
Yes, Your Honor. It was expressly raised in the lower court by counsel for Mr. Jones.
And when you say expressly, what page of the record are you referring to specifically?
It was record at Record at 1094, Your Honor.
Yeah, because let me follow up on that, because on 1094, there was a motion, you filed a motion to conform the evidence to the pleadings. And the judge's response was the court is going to consider the defense's theory on the pleadings to that evidence elicited by both the plaintiff and the defendant. Now, in your brief, you say that the motion was granted, but I'm not sure by that language that the judge granted it, particularly given that the judge did not even address collateral estoppel in the final judgment. So is there something I'm missing as far as what the judge said that indicated he granted your motion?
Your Honor, in the lower court during the proceedings, both from the beginning, including the summary judgment, the collateral estoppel issue was discussed, and at that time, in the context of that conversation, that was merely a question of whether to use the federal court term or the trial court term that was used in this case.
Well, is there any discussion other than on pages 1092 to 1094 of the record?
If you look at record 582 to 674 in the motion for summary judgment, it is addressed, Your Honor.
And at record 587, the response to the summary judgment refers to res judicata. And that was also what was pled as an affirmative defense at 310. It was referenced as res judicata in the argument. When there was an objection to collateral estoppel being considered because only res judicata had been pled, the discussion was, I think it's just a federal term, it's the same thing, it's res judicata. There was no discussion of res judicata, of collateral estoppel in the final judgment. There was no discussion as to the elements of collateral estoppel. So what are we missing in that collateral estoppel is not actually presented below?
Your Honor, respectfully, it was that's a form over substance situation that was discussed.
It's kind of a due process argument, right? Because our law, our legal system allows individuals to address legal arguments in the context of legal proceedings. So if that was not presented, how is that a form over substance issue?
Well, yes, Your Honor. I respectfully, the way that it's presented was, for example, in the Picciotto, it was presented as both, even though they discussed the res judicata issue, but they didn't really discuss the collateral estoppel issue in that case. Independently, though, even if you take out the collateral estoppel argument, each of these three arguments are positions are reversible error. So you don't have to pick them all. You just have to pick one. So if collateral estoppel is something that you're concerned with because of how it was written in the record, the res judicata argument, which is actually the one that is a case of first impression for this court, because none of the cases that are present in the precedent right now are involve this particular case, involve the situation where
let me ask you about res judicata and even collateral estoppel in the context of the alternative count, which was for equitable subrogation and an equitable lien based on the lack of a legal obligation. How would res judicata and collateral estoppel preclude litigation of the equitable subrogation claim?
Yes, Your Honor. The res judicata is for every fully litigated issue, every justiciable issue. And in the 2015 case, appellees in their motion for reconsideration / rehearing addressed all of the same issues: the equitable subrogation, the equitable lien, the Scrivener's error, the reformation, and Judge White denied that motion for reconsideration. And so since the opportunity to address those issues, if they believe that Judge White missed it in the 2015 case, their remedy was to go and appeal it to to the 5th District Court of Appeal after the 2015 case. They did not do that, even though it was fully litigated, and that was their opportunity to do that. So for them to come again and take a second bite at the apple is where the reversible error occurred, not having res judicata apply to this case. It was expressly denied. The final judgment in that case precluded any future cases, because in this case there is no continuing obligation. There is no subsequent default, such as the Singleton line of cases. And so there is no ability to, oh, well, there's a new default, so there's a new case. This is not this case. This case doesn't fit into that square hole. We can't say there's a new default because the underlying obligation itself was deemed invalid. And so there can't be a default later on. Your Honor, again, with the issue of having gone through the issue of collateral estoppel, and third, the court erred in reforming the note when the issue of reformation had been brought up in the prior case and was denied as the evidence did not support reformation. Again, in this case, appellee Dutch Bank failed to provide evidence or proof that the mistake was mutual or that there was a unilateral mistake and that appellant Jones acted inequitably. Indeed, the testimony of Lawrence Nardi on cross-examination shows that appellee Deutsche Bank, through its onboarding process, was satisfied that the note and mortgage were 100% accurate, record at 1078. The lack of evidence as to mutual mistake or unilateral mistake and inequitable conduct requires reversal of the court's reformation ruling. In addition to the above, the arguments of res judicata and or collateral estoppel furthermore apply to the reformation count. Judge White had the opportunity to review and hear the issue of mistake and reformation, again, in the motion for reconsideration and or rehearing in the 2015 case, record at 1236 to 1290, and rejected that argument. Therefore, it was reversible error for the court to reform the documents in this matter. Your Honor, the proper application of res judicata mandates reversal on the grounds that the promissory note was held to be invalid and unenforceable, and the arguments of reformation, equitable lien were rejected in 2005 and should not have been relitigated on those grounds. This is not the situation where we have a subsequent default. This is a situation where the underlying obligation in a fully litigated case in 2015 that went all the way through to non-jury trial and final judgment, that obligation was deemed to be invalid. And for the foregoing reasons, appellant respectfully requests that this court reverse the verdict and remand with instructions to enter a verdict in favor of the appellant.
Okay, thank you.
I'd like to reserve the balance of my time.
Okay, for the appellee.
Good morning, Your Honors. May it please the court, Adam Weichling on behalf of the trust appellee. I wanted to start out by reciting some of the important language from Bartram, the 2016 case, Florida Supreme Court decision. In quoting its own decision in Singleton, reiterated that if the plaintiff in a foreclosure action goes to trial and loses on the merits, we do not believe such plaintiff would be barred from filing a subsequent foreclosure action based on a subsequent default. The adjudication merely bars a second action relitigating the same alleged default. The court continued, stating that it agreed with the analysis of the Middle District of Florida Court in Dorta, that where a mortgage foreclosures action is unsuccessful for whatever reason, the mortgagee still has the right to file later foreclosure actions so long as they are based on separate defaults. In Bartram, the court continued, whether the dismissal of the initial foreclosure action by the court was with or without prejudice may be relevant to the mortgagee's ability to collect on past defaults. However, each subsequent default accruing after the dismissal of an earlier foreclosure action creates a new cause of action, regardless of whether that dismissal was entered with or without prejudice, excuse me. And one last point from Bartram, the court held, as we cautioned in Singleton, justice would not be served if the mortgagee was barred from challenging the subsequent default payment solely because he failed to prove the earlier alleged default. Foreclosure is a proceeding in equity, and the two defenses raised here on appeal, although not, as the court pointed out, not below, of res judicata and collateral estoppel are defenses that arise only in equity. And the Florida Supreme Court for instance, in the State versus McBride case, has held that res judicata will not be invoked where it would defeat the ends of justice, and collateral estoppel will not be invoked when doing so would result in a manifest injustice. And here, applying either defense would be manifestly unjust because that would require this court to overrule Bartram and require giving life to a phantom September 2006 note and mortgage that Mr. Jones admitted does not exist. The trial court correctly concluded in this case that the reference in the 2008 loan modification to the note having a date of September 2006 was a Scrivener's error, and the operative note and mortgage was the June 2006 loan foreclosed on here. The facts, as the court observed, I know you said that you know them all, that are familiar with them all, but they are largely undisputed. As stated in the parties' pretrial stipulation, the June 1, 2006 note and mortgage paid off the prior loan on the property and paid Mr. Jones $10,945.69. Mr. Jones signed a loan modification dated August 29, 2008. The foreclosure lawsuit in this case raised a different default than the prior lawsuit. And after the modification, Mr. Jones made payments, but none since at least 2013. The modification wrongly referenced the note date as September 6, 2006, rather than June 1, 2006. But Mr. Jones admitted in deposition in this lawsuit that the June 1, 2006 note and mortgage were the last one that he executed relating to this property. So there was no phantom 2006 note and mortgage. And at the 2019 trial, the trust offered testimony about how the misdating on the modification, which was coincident, or offered testimony about how the misdating came about, which was coincidental with the transfer from one prior servicer to the next. In the the first foreclosure case, which had the 2016 trial, the only defense to that case that was stated is statute of limitations. And at trial, in the second case, because there's no record from the trial of the first case, but at trial in the second case, Ms. Rahm testified that she pointed out to the court that the note was from June 2006 and the modification referred to a September 2006 mortgage. And from that, the trial court in that case concluded that that meant that the trust had failed to prove the September 2006 note and mortgage, the phantom note that doesn't exist. Despite the fact that even if it did exist, it would be a second mortgage and it would be it would not supersede the June 2006 mortgage. As the courts observed, after the 2016 trial, the trial judge did not cancel or void or declare permanently unenforceable the June 2006 note and mortgage. The evidence in the second trial was different. The trust was within its rights to file a second proceeding in accordance with the Florida Supreme Court's language in Bartram, holdings in Bartram. And this is an equitable proceeding, and this is a case where Mr. Jones admitted that he signed the trust note and mortgage and loan modification. He admitted he paid on the loan modification. He admitted he hasn't paid since 2013. The trust loan paid off the prior mortgage and paid him $10,945.69. The trust paid the property taxes and insurance for the property since at least September 2012, including after the first foreclosure trial. Mr. Jones ratified the mortgage contract by making payments after he signed the loan modification and after it was implemented in the trust system. Mr. Jones admitted that he didn't sign any mortgage after the June 1, 2006 mortgage. So here, it would be inequitable to apply res judicata or collateral estoppel to overrule Bartram. And certainly allowing those defenses here would be manifestly unjust because it would hinge on giving life to a phantom 2006 mortgage that appellant admitted himself did not exist. There's no dispute that the modification was intended to reference the June 2006 note and mortgage. And appellant's theory on these defenses would essentially render Bartram and Singleton meaningless, because collateral estoppel, or whatever they wanted to call it here, issue preclusion, would regularly apply where an involuntary dismissal was entered following any litigation on the merits. But as appellants appear to have conceded by claiming that this is a case of first impression, there's not a single appellate foreclosure case doing what they've asked this court to do. Bartram does not support them. The Picciota case from the 4th DCA defeats their position. And for those reasons, the judgment on appeal should be affirmed.
All right, any other questions from the panel? Okay, thank you. Rebuttal.
Thank you, Your Honors. Respectfully to counsel for the appellee, the appellants do not seek to overrule any of the line of progeny. What we're saying is that Bartram and Singleton and all that line of cases does not address this case. This is a case that's completely distinguishable, and that's what makes it a case of first impression. In that in any of those, not one time is the underlying obligation declared invalid. In all of them, there's a valid case. That is to say, the bank upheld their burden of proof on the existence and validity of the underlying obligation. Whereas in this case, the appellees failed to do that against a pro se defendant, no less. They failed to prove that the note on June 6th was a valid note. In the final judgment for the defendant's record at 1135, Judge White expressly stated in subparagraph C, defendant John Kevin Jones presented testimony challenging the enforceability and validity of the June 1st note and the June 1st mortgage. And paragraph D, plaintiff failed to prove by the greater weight of the evidence that the June 1st note and the June 1st mortgage are enforceable or valid. This is where the bank had the burden and the bank failed to uphold that burden. If they felt the judge made the mistake, that's what the appellate process is for. The appellate process in 2015, not the appellate process today. This is where it's different from Bartram. The Singleton versus Guimar line of cases remains intact. This is merely one of those, the one case that doesn't fit that. If there's a situation where the underlying obligation is deemed to be invalid, then res judicata does apply, because the same exact fact pattern, the same exact testimony was given in both cases. This is not a dismissal. Counsel for the appellee focuses on Bartram and it's not a dismissal. This was not a dismissal. This was a full non-jury trial adjudicated completely on the merits. And was held to be invalid. So the manifest injustice arises from allowing the bank to come back to yet another non-jury trial and go through yet another non-jury trial to receive an inconsistent ruling, when in fact the res judicata should have precluded that trial from happening altogether. This is where we need to hold the banks to the fire when it comes to proving up their case. This is no different than anyone else. They were required to prove it up and they failed to do that. Joni Rahm did raise the invalidity of the note at trial at record at 1091, 1092. It's referenced in the final judgment for the defendants. And that's where we come down, Your Honors. We have to hold the banks to the fire. We have to, if they don't prove up their case and they think that the judge has made a mistake, then their job is to go up to the Court of Appeals in that case, not say, oh, we're just going to start over and pretend that this didn't happen and start again. Because in this case, you can't do that. In this case, there cannot be a subsequent default because the underlying obligation itself was deemed invalid. So there's no need to overrule Bartram. There's no need to overrule any of the cases. This is merely one case that doesn't fit. It's that rectangular peg that doesn't fit in that square hole. A non-jury trial completely adjudicated on the merits where the underlying obligation was held to be invalid, res judicata applies to any subsequent case because there can be no continuing obligation on a contract or obligation that's been deemed invalid by a court. Thank you, Your Honor.
Any other questions? I thank you both for your arguments. Much appreciated, and we'll be in recess.
Thank you, Your Honors.